Good morning. I hope everyone had a great weekend and a joyous Juneteenth. And we've got, so this morning we have 4 cases that are on the docket. 3 are going to be arguing this morning. I'll be calling all of them. And for those that are arguing, when I get to your case, if you can please present your name and your readiness to proceed. So the first case is C220457, State of Ohio versus Brittany Lewis.
Brian Smith, I'll be back. Sean Allen,
Thank you. Then we have case number C220537, State of Ohio versus Fry, and this case has submitted on the briefs. Case number C220570, State of Ohio versus Fritsch. Good morning.
Again, Your Honor, Sean Allen, I'll be behalf of the state ready to proceed.
You're the big winner today.
Yes, ma'am.
Okay. And then the last case we have is case number C220430, 436, In Re LES, ES, and NS.
Jonathan Hilton for Ms. Carmen Edmonds. Ready to proceed.
Good morning. I think I saw counsel, yeah.
I have seen Mr. Durst here today. I believe they will comment for you.
Okay, and we'll presume that they're ready to proceed then. Thank you. All righty, so we'll start with with State of Ohio versus Lewis. And whenever you're ready.
May it please the court. My name is Brian Smith on behalf of the appellant Brittany Lewis. I'd like to reserve 5 minutes for rebuttal. Your Honors, the trial court erred in denying the motion to suppress that was filed in this case. The suppression motion concerned specifically the search of the appellant's purse that was conducted independently of the search of the vehicle.
Mr. Smith.
I'm sorry.
Sorry.
I was going to say, you complained of both, right? Why were you complaining with regard to the vehicle?
Well, with respect to the vehicle, neither the search of the vehicle nor the purse fell under any warrant exceptions. So it was a warrantless search, so there had to be probable cause, and it had to fall within one of the exceptions to the warrant requirement. And those conditions were not met in this particular case.
But even if there wasn't probable cause for the vehicle, how would that have impacted the purse?
The officer used the reasoning for the search of the vehicle as the same reasoning for the search to support the search of the purse. One more or less led to the other, because the officer Clark testified about this at the suppression hearing, that he based the search of the vehicle on what he called a strong odor of marijuana that was coming from the vehicle. And so this was what led to not only the search of the vehicle, but ultimately the search of the purse. Because when they were stopped, the appellant left the vehicle. She walks about 50 to 75 feet away. Once the officers are searching the vehicle, she comes back to the vehicle. She returns. Then the officers search her purse. So they use the same justification for searching the vehicle as they did for searching the purse. And that's where the error comes in, because it doesn't fall under any of the warrant exceptions. And as this court has held in State versus Curry, the odor of the marijuana is not enough to necessarily search the entire vehicle. There has to be more than that. And that was the only justification that the officer cited, other than the arrest, Dukes' warrants to search the vehicle.
Mr. Smith, as far focusing in on the purse itself, is it a bright line rule that once the person with the purse has left the car with the purse, that it no longer falls under the automobile exception?
I wouldn't necessarily call it a bright line rule, but in this particular case, there was no justification for searching the purse. And it's because ultimately the court could almost look at it as another separate compartment. This court has held there, for example, in, I believe it was State versus Curry, that there has to be more than an odor of marijuana to search compartments within the vehicle.
So it doesn't matter that she had already left the car with her purse and walked away, and that the purse was no longer in the car? Are you saying that
It does matter because if anything, it makes it less likely that there would be probable cause to search her purse once she's left the vehicle, especially since Officer Clark testifies that the search was based on the odor of marijuana that was coming from the vehicle. Clark testified this odor of marijuana is coming from the vehicle when the officer walks up to the vehicle and confronts the driver, confronts Donnie Dukes. So,
well, looking at case law, I mean, it seems like all the cases that I've researched, when officers have searched a purse, it's been when the purse was in the car, correct?
usually, yes.
Okay,
But in this case, it was the purse was taken out of the vehicle.
correct.
She came back with the purse.
It didn't get back in the car, right?
No, she did not get back in the car. She stood about 50 to 75 feet away during the encounter between police and Dukes. They arrest him. They begin searching the car. She comes back. That's when the officer searched the purse. So it takes place. So no, she doesn't actually get back in the vehicle, but if anything, that gives the officers less justification to search, because at that point the purse is no longer in the vehicle anyway. So our argument would be there would have to be a separate justification for searching the purse, because she walks away, she's no longer in the vehicle. So what's the justification if this is either being conducted as a search incident to arrest or because the officer smelled marijuana? The state can't point to any justification for searching her purse as part of those exceptions.
She was in handcuffs when they searched the purse, but it sounds like both parties are arguing that she was detained for a search rather than arrested at that point.
I believe initially that was the reason. Yes, she was detained at that point because she's not going to be free. A reasonable person in that situation is not going to feel free to leave under those circumstances. And we would submit that she's not free. A reasonable person wouldn't have felt free to leave at the point the officer stopped the car, even when she's standing on the grassy knoll about 50 to 75 feet away, or else she would have left. So at that point, she's in custody, effectively in custody by not feeling free to leave. And
So do you believe that it could be a search incident to lawful arrest?
not in this particular case, Your Honor, because as this court has held in State v. Jones and I believe earlier in State v. Gant, there has to be the search incident to arrest must contain evidence of the offense of arrest. So if Dukes was being picked up on warrants, if he's being picked up on warrants, there's no justification for a search incident to arrest at that point, unless there's the officer never pointed to, we're
No
looking for
justification
evidence.
as to your client.
I'm sorry?
No justification as to your client, is what you're saying.
Yes. Our argument is limited to Ms.
Right.
Lewis, or to appellant, of
I
course.
want to go
But
back to your argument with regard to the basis was the strong smell of marijuana coming from the vehicle, or the smell of marijuana coming from the vehicle. Because she is present in the vehicle, the purse is with her present in the vehicle, wouldn't that justify the search of the purse regardless of where the purse was, because the purse was part of the vehicle when the odor of marijuana was detected?
no, Your Honor, because the odor was coming from the vehicle, not the purse itself. And this court's...
You're making it sound like we're going to be then searching the engine, because that's the vehicle. It's really coming from the vehicle and its contents.
The odor doesn't necessarily give officers justification to search the entire vehicle, though. Only because there's case law, for example, in State v. Curry, the officers need more than that to search compartments within the vehicle. So, for example, a glove compartment or maybe a center console, a trunk, some compartment within the vehicle. The purse could really be looked at as one of the, if anything, as a compartment of that vehicle. So it's entirely consistent with this court's prior holding in Curry, in citing United States versus Ross from the U.S. Supreme Court, that there has to be more justification than simply an odor of marijuana, even if it's a strong odor, to search compartments within the vehicle, which in this case, even looking at it favorably to the state, would include the purse. The purse could almost be looked at while appellant is in the vehicle as a compartment within that vehicle.
Vega is one of the cases I believe that you cite coming from the Ohio Supreme Court. Do you recall what were the areas that were searched in that case?
I believe in Vega it was the glove compartment, but I'd have, Your Honor, I'd have to double check that. But
Because I believe in that case, it was the Court of Appeals was reversed, and it was found to be a lawful search.
I believe that was correct, Your Honor. However, there would still be, I believe there would still be room for an exception under under this court's case law in State v. Curry, and under United States versus Ross, as well as State versus Moore, which is the other Ohio Supreme Court case on point. I believe there would still be room for that exception, that an officer needs more than simply an odor of marijuana to search compartments or segments of a vehicle. And the reason for that is there has to be, if that's the basis for the search has to be limited to finding evidence of the unlawful activity. There has to be some nexus or some connection to why the officer is searching, or else essentially becomes a pretextual search where, well, we smell some marijuana, so let's tear the car apart and see if we can find some other evidence, or get into find some other evidence of some other crime that we think might be out there. I mean, that's going beyond the scope of what this court and frankly what the Ohio Supreme Court and the U.S. Supreme Court have said is permissible under the Fourth Amendment.
Unless there's any other questions.
Yeah, I do have a question. I asked this with some reluctance because neither of the parties argued this. But my understanding of the facts are your client's in a car that parks in a no parking zone. Police run the plates. The warrants come back on Mr. Duke's felony warrants. Your client's out of the car. She goes somewhere. She comes back. At the point she comes back, according to the exhibit, the video, she walks back, and at that point, the police have searched the car and recovered the firearm. And as they walk up to her, I see them remove her purse, cuff her, and say, "This is now a firearm investigation." And although it wasn't argued, could you look at this as a Terry stop? Because the things that are known to the police at that time, they see her in the car, they search the car, they find a gun that she had just left, and her purse certainly could have concealed a gun or a knife or a weapon. Could the court have been right for the wrong reason in this particular case? And tell me why that's wrong.
I don't believe so, Your Honor, in this particular case, because one, the stop I believe was based on. I believe it was based on running the plate. I'm not sure about whether it was illegally parked. I know there were. I'm sorry.
Yeah, that's right. Warrants, and just assume, for the sake of that question, that the odor of alcohol was sufficient to allow the police to search the car. My question focuses on your client. She was in the car, out of the car, searched.
I don't believe Terry would justify the search of the purse in this case, Your Honor, because, for one, Terry is based on officer safety. That's the main justification behind underlying the Terry decision. At this point, once the appellant walks away. She walks away from the vehicle and she stands at a grassy knoll or grassy area roughly 50 to 75 feet away. There's no indication that she goes and gets a weapon and comes back. She simply walks over, stands there, watches what happens, and comes back. Sorry.
If you want to pause and get some water, that's not a problem.
I feel you. I think I have the same thing you have.
Yeah, but yes, thank you. But no, Terry would not justify in this case because at this point it becomes a search.
Not a problem.
At this point, it becomes either as the state has argued, either a search incident to arrest. It becomes a search based on the smell of marijuana. There's no independent Terry justification for searching the purse at this point because, again, she's within sight of the vehicle. Obviously, if the officers can testify as to where she's standing and how many feet away she is, they're able to see her. So the officers know that there's no, it's not as though she disappeared, went into a house and came back and could have potentially had a weapon or posed some other threat to the officers. So in this particular case, no, we would submit that Terry is inapplicable as far as searching the purse.
Well, let's say that Terry did apply here, and the officers did search the purse. Does that give them the right to search the pill bottles? They find no weapon, because she didn't have a weapon. Do they have the right then to search those pill bottles?
We would submit no, because at this point the evidence would not be sufficient. There would not be probable cause to believe that the pill bottles contained contraband. So there would have to be a separate justification for. There would have to be a separate justification for searching the pill bottles, independent of searching the purse. And I just want to brief, if there are no further
Well, why don't we
questions.
reserve your 5 minutes?
Oh,
Okay.
yes, thank you. I'll reserve the remainder of my time for rebuttal.
worries.
Thanks, Your Honor.
Morning, Your Honors.
Good morning.
I guess I'll just go in reverse order of some of the notes and questions that I heard. To answer your question from the state's perspective, no, I don't believe that Terry would get you into the pill bottles. Arguably, perhaps not into the purse. That would be a different issue. And as Judge Winkler pointed out, it wasn't directly litigated. So I don't have sufficient facts on that. But no, I don't believe that a pill bottle would have been capable of containing a weapon. It would have been readily apparent for a pat-down search. So yes, I do believe that there was sufficient evidence in there, the presence of a firearm, open felony warrants, to do a Terry pat-down. However, I don't believe that that justifies the search that was conducted here. Segueing into Your Honor's question about Vega and everything like that, the bright line and black letter law in Ohio is that the odor of marijuana in a vehicle detected by an officer trained in the detection of that, who can speak on that, which is what happened here, gets you into a search of the passenger compartment and containers in the passenger compartment that could have contained contraband. Curry and the cases like that don't deal with a glove compartment, don't deal with the center console, they deal with getting into the trunk. And the odor in the passenger compartment doesn't get you into the trunk. And there was no search of the trunk here. But the odor was sufficient for the officers to then search the backpack. They then find contraband in the backpack. They then find the weapon. And that's kind of one of the things that changes a lot of the parameters here. Under Mercier, however they want to pronounce it. I don't know if the I is pronounced in that case or not. In that case, this court discussed whether or not an individual could remove a purse from a vehicle and kind of obstruct its ability to be searched at that point. And this court found that no, they could detain that person. They could search that purse and insist that that purse be remained, and that I'm getting right there.
Okay.
I promise. I promise, because I believe that that's the key issue here. So had the vehicle, had they arrived, and I said this in my brief, had they arrived a minute earlier and approached, bright line rule, there's nothing wrong here. The question then becomes, as Judge Bach was asking about, and I want to address, she did leave the vehicle, and she walked a short distance away. She then voluntarily reinserted herself into the situation. She wasn't being detained. I disagree with counsel's characterization that she didn't feel like she could leave. They had all their focus on Mr. Dukes. When he starts coming out of the car, they've got 4 open warrants. They can't see through the tinting on the windows. Their focus is directly on him.
And there are other bases to handcuff someone
Yes, ma'am.
besides a full custodial situation.
Yes, ma'am. And I believe that, and this specific issue wasn't addressed, but I believe that had it not been open felony warrants, had it not been the presence of a gun, that Ms. Lewis would not have been handcuffed while they searched her. But we do have violent felony warrants. We do have the presence of a gun. The gun was in the center console, right where she had just been. I would say that there's more than enough probable cause. We've got the odor of marijuana. We've got the presence of the gun where she was sitting. She expresses an interest in the vehicle when she walks out. Why are you searching my car? We know that it's not her car. That's registered to Mr. Dukes, but he's unlicensed. But she referred to it as her car. Can I get my phone? Her phone is sitting on the seat right next to where the weapon was found. And I think that all of that, yes, I believe that this is an odd case in terms of, had she kept on walking, I don't believe that they're going to chase her down. I believe that they would have had reasonable articulable suspicion to go over and detain her. Arguably could have had probable cause to pursue her and collect her and say, no, come on back here. She voluntarily reinserted herself into the process. I believe that the court even said that there's no indication that she left, that anything had changed, that had altered. She did not go into any buildings. She stood a short distance away, came back, and I believe that their ability, their probable cause, their authority to have detained her at the scene, had they been a minute earlier, they would have had the authority to detain her there as part of their investigation. And I don't believe that that dissipated in the short distance that she traveled and walked back. It's a very unique set of circumstances. I do not have any specific case law on that, but I think that the rules that we have in Houghton about the portability of contraband, the ability for a passenger, a co-passenger in the vehicle to become an unwitting participant, as Mr. Dukes claimed at trial, or that the person is a knowing accomplice, as ultimately the court found in its sentencing entry and in her conviction. I believe that those would be thwarted by saying that this brief temporal pause when they had authority divested them of that authority when she reinserted herself. Does that answer the question that you had, ma'am?
Yes.
Okay. I've thrown an awful lot out there. I want to make sure that I'm addressing the different questions.
Do you want to address the issue on the jurors' questions?
I can, yes, Your Honor. I think that as I recall in this, and I assumed that the primary focus was going to be the motion to suppress, but the jurors' questions were discussed at length how they were going to be addressed. Ultimately, even if the answer were incorrect, I don't believe that there's been any showing of prejudice if they got the order wrong, or if they shouldn't have given the order, the order in which the pills were not a court order, but the question was about the order in which the pills
And the packaging.
were found in the packaging and everything like that. I don't believe that there was anything incorrect in what the court said, but even if it were, I'm not sure how that would have been prejudicial. I don't believe that there's been a demonstration of how that prejudiced Ms. Lewis, or how that would, even if it were an incorrect, and the court abuses discretion in giving that instruction after discussing it with counsel, I don't see how there's prejudice that swayed the jury or affected the outcome of this trial.
It's my recollection, and I might be wrong about this, that I believe at one point defense counsel said, when this was being discussed, defense counsel said there was just so much testimony. But did defense counsel say something about how it could be a summary of the testimony?
As you're saying this, I think I'm right there with you.
And is that what the
I
trial
have-
court did?
I think to the extent that it wasn't a verbatim recitation of testimony, pointing to somebody or rereading it, and to the extent that it wasn't somebody else's exact words that were being put to the jury, that could be a characterization of it. Anything, unless I'm using exact quotes, I'm summarizing what somebody else said. I might be saying it exactly in the same way and saying the exact same thing, but I think it's a fair characterization of it, that it could be considered a summary. Yes, ma'am. I don't think there's any indication that it was an inaccurate summary. So even if, I go back to the point that I was making a moment ago, that even if it were inappropriate for the court to have done it in that fashion, I don't believe that any prejudice has been demonstrated in that conduct. If there are no further questions.
Thank you.
Thank you.
Just very briefly, the search was not justified even under State versus Vega, because once the appellant leaves, the purse is no longer it's no longer a compartment in the vehicle. The initial search of the vehicle was justified based on the odor of marijuana, and that was the odor of marijuana that was coming from the vehicle, not from the purse, because at the time the officer smells the marijuana, she's 50 feet away with the purse. So that was the justification. So even under Vega, which I articulated perhaps a different legal standard, it's still not a justifiable search. I want to talk briefly, and she wasn't detained for officer safety, it was to search the purse. That was really the goal or the reason why she was detained. And there's no independent safety justification for searching the purse at that point, because, again, she's detained, they've already found the gun inside the car. Once she's handcuffed, where's the justification to search the purse? So that's where that.
I want to go back to something you started off saying. So you're saying by the time the officer smelled the marijuana, she was 50 feet away, right? Did the officer testify that they had visually observed her leave the vehicle with the purse in hand?
I believe his testimony was that he couldn't see what she had on her person or whether she had the purse, but she did have the purse on her when she left, because when she came back, when she returned to the vehicle, she had the purse. That's when she was detained. That's when officers searched the purse. So whether Clark or whether the officer testified that he saw her leave with the purse. I'm not sure if he was able to conclusively identify that she had it on her person at that time, but she did have it because it was on her when she returned.
Okay.
I hope that answers your.
It does answer my question, because then my follow-up question is, you know, it seems as if you're drawing a line of distinction as to when the probable cause occurs, and that then defining what could be searched, regardless of the information that the officer may have at the moment that the probable cause surfaces.
The officers never had probable cause to search the purse in this case because the original investigation was it was based on the warrant. That was the reason for the initial encounter where Dukes' felony warrants. So then the officer comes up to the vehicle, smells marijuana. They stop the vehicle. She gets out, walks away. Officers come up, smell marijuana, conduct a search of the vehicle, whether it's the compartments, center console. They conduct a search of the vehicle. She then returns to the vehicle, apparently to retrieve her cell phone, which was found in the vehicle. And that's when officers detain the appellant and search her purse. So at no point in this entire encounter do
But
officers.
isn't the search at that point premised on that that purse was a compartment in the vehicle, and that it would have been at the time that the marijuana that was smelled would, if it exists, when the marijuana was physically present?
But it's not a justification. That may have been the state's justification, but it's not a sufficient justification under the Vega standard, because the smell of marijuana is independent of where the purse is located. In other words, the purse is not in the vehicle when the officer smells the marijuana. So there's no justification, even under Vega, for the officer to search the purse in this case. There's no justification for claiming that the purse is for lack of a better term, a compartment of the vehicle, because she's already standing away from the vehicle at the time the officer smells the marijuana. Now, hypothetically, if she had left the purse in the car and walked away, we might be arguing this differently or not at all. But those are the facts as we're given.
That's what I find interesting. You're drawing a line of distinction of whether the purse is in the car when the officer approaches the vehicle and smells the marijuana, versus whether the purse, which would have been in the car otherwise, is now outside of the car when the marijuana is detected.
It's an important distinction to make, Your Honor, because the officer specifically cited the intensity of the odor of marijuana in this case. When the officer testified, it was, quote,
Isn't that reflected that it could be in more than one compartment? Because if it was a mild odor of marijuana and the purse was no longer in the vehicle, then the argument could be made that had the marijuana been in the purse, it would not have been smelled because it was so mild. But if it's an intense odor of marijuana, couldn't the argument be made that that means that there's a larger amount, which could be in a variety of locations?
I don't believe so, Your Honor, because if it's a strong odor when he comes up to the car, that would indicate that the source of the marijuana would have still been inside the vehicle. If say, for example,
That would be premised if there's one location of the source of marijuana.
Or there could, or hypothetically, if the state is going, I mean, if the state's argument is there could be more than, or if the argument is there could be more than one location, that it wouldn't have necessarily, and the odor is strong, it doesn't necessarily indicate that there could have been marijuana in the purse in those particular cases. If it's a strong odor that's coming from the vehicle and the purse is no longer there.
Was there any testimony about whether the smell was of burnt marijuana or of unburnt marijuana?
I believe it was just, The
Or was
officer
it just
indicated
general?
just marijuana. I'm not sure if there was a distinction made between burnt and raw. I don't believe there was.
Okay.
And it was on page 26 of the suppression hearing transcript. If I can just talk very briefly about, I hope that covers your, answers your question. If I can just talk very briefly about the juror question. The prejudice was in harmonizing the answers about whether the blue pills that were in the container were loose or packaged together. That was where the prejudice came in. It wasn't the order. The state and defense counsel agreed on the order of the pills in the bottle. It was whether the pills were loose or packaged separately, because Dukes testified that he put them in the bottle, and that appellant had no knowledge of what was in the bottle. So that's, and in fact, the officer gave inconsistent statements, because I believe at 456 in the trial page 456, the officer testifies that it contained the pills, and then 2 pages later in the transcript, page 458, he describes the pills as loose. So there's some inconsistency there, and what happens in the juror question, the answer to the juror question was prejudicial, because essentially it harmonizes these inconsistent statements from the officer into one answer. In a case where the jury, obviously, the case where the jury was inquisitive enough or didn't remember the testimony well enough to where the juror question was necessary, it has the effect of essentially overpowering the collective memories of the jury and essentially harmonizing these answers, these inconsistent answers for the jurors who are trying to recall these specific pieces of testimony. So that's where the prejudice comes in, is essentially unfairly lends credibility to the officer where it would not have otherwise been there. And I'd be happy to take any questions with my remaining time. Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. We're going to take the matter under submission and issue a timely decision. Attorney Smith, have a wonderful afternoon. Have a wonderful afternoon.
Thank you.
Okay, thank you. State of Ohio versus Fritsch.
Good morning, Your Honors.
Good morning. How are you doing?
I'm good. How are you?
Good.
May it please the court, opposing counsel, I would like to reserve 3 minutes for rebuttal.
Okay.
There is more than meets the eye to this OVI case, and that has to do with the substantial nexus issue. But first, I would like to address the final appealable order issue raised in the state's brief, as I believe that does have potentially far-reaching implications. So the state claims that the judgment entry in this case does not comply with Criminal Rule 32C and is therefore not a final order. They cite this court's decision in State versus Daniels for the proposition that multiple documents cannot be considered to yield a final appealable order. The state further claims that the 2 pages appended to Mr. Fritsch's merit brief cannot be considered together, and they ask this court to dismiss the appeal. So the seminal case on this issue is State versus Lester. We're all familiar with it. And the 4 components in that case, the state criticizes the fact that the first page of the judgment entry with the lines contains the finding of guilt, and that the second page contains the sentence and the judge's signature. And they claim that both pages cannot be considered together to yield a final order, and respectfully, this is wrong. So to satisfy Lester and 32C, there must be a single judgment entry, not necessarily a single page. So as you know, common pleas cases are always comprised of multiple pages. In these municipal court, the bane of a lot of our existence, these judgment entries that are handwritten are kind of hard to follow. But there are 14 municipal court judges. Some of them, to write their entries, use the front page. Some use the reverse side, and some use both. So the key, and I think this is where we distinguish Daniels, is that so long as any of those pages are journalized together simultaneously and they have the same date. And that is key when we look for final judgments when we file an appeal. So long as those components are met, it is a final appealable order, so long as the rest of the lesser requirements are met. So here, the first page with the lines contains the clerk's stamp, which indicates entry upon the journal, and then it contains the finding of guilt. The reverse side contains the sentence and the judge's signature. Those pages, they look like they're separate when they're scanned in because they're on reverse sides of each other, but they were journalized together and they bear the same date. So we submit that that is a final appealable order, and a holding to the contrary would confuse the issues and really kind of rock the boat in municipal court and the clerk's office. If there are no questions on that issue, okay, I'll move on. So I'm going to focus on the second assignment of error, which is the sufficiency assignment. And, Ohio appellate courts have reversed OVI convictions where, despite the fact that the accused appears to be under the influence of something, the state fails to establish a connection between that impairment and alcohol or a drug of abuse. So, State versus Husted, cited in our brief out of the 4th District, that was where a physical control conviction was reversed because there was no evidence that the appellant's condition resulted from being under the influence of a drug of abuse, and noting, quote, there was no evidence about what specific drugs she had consumed. And the same holds true in this case. State versus...
Wait a minute, Counselor.
Yes.
Mr. Fritz, am I saying that correctly? Fritz, he admitted that he had been drinking. And didn't he actually say that he was under the influence?
So he said in the post-arrest interview that he had consumed 2 beers over the course of like 24 hours. And then the under the influence question, he also, the officer asked him that, and I don't think he knew that this was a legal term of art, under the influence. I think that the average person might hold that on par with, did you drink anything? So, in the law, under the influence means something. I don't know that the average person knows that that means appreciably impaired to the point you shouldn't be driving. And, there's the difference with this case and many others, and I spent a lot of time reading the Bowden case out of this court from 2020. I think Bowden needs to be tightened up just a little bit, respectfully, because this court held that there does not need to be a link to a specific drug, that the law does not, said something like the law does not require as much. And respectfully, the case cited for that proposition is Richardson out of the Ohio Supreme Court. The proposition of law that was accepted in Richardson, it was a state's appeal. The proposition was, when a drug of abuse is at issue in an OVI case, evidence that the defendant was driving impaired combined with evidence that the defendant took a specific drug of abuse at the time is enough to meet a sufficiency challenge. So that case is upholding the standard of you need some evidence of a specific drug. In the Richardson case, the defendant said he had ingested hydrocodone. He said, I've been taking it a while, that doesn't affect me anymore, but it didn't matter. The Ohio Supreme Court reversed the 2nd District and said that the multiple things that showed that the defendant was impaired, and we do have, in this case, I will concede, there are odd circumstances present that shows that there's sufficient evidence construed in light favorable to the state that says, yes, he seems like he was impaired. That's only half the equation. The other half that Richardson requires, that these other cases, the Collins case out of the 9th District, the Turner case out of the 8th District, you read a lot of these cases, you see these facts, and you're like, this person is off their rocker. Driving a car probably shouldn't be. They still reversed. They said that is not enough. And the reason for that, think of the overarching reason we have this system set up, is that police need to be able to do their job. That's one side of the scale. The other side is they can't just have a hunch and say, I think someone's on something. I'm going to go ahead and bring them in. I'm going to arrest them. There has to be something more.
But in cases where a person has ingested illegal drugs, maybe at home, and then are in their car and driving and kill somebody. So can we just say, well, there's nothing at the scene showing what drug they're on, so, no, we can't arrest this person?
Well, there would be at least vehicular homicide charges
Okay,
for that.
let's take that out,
but,
let's take that
you
out of the
know,
equation. They're driving erratically, and an officer pulls the person over.
Right.
Or they're driving through the grassy part of a park, and the officer pulls them over. I mean, are we just supposed to throw up our hands and ignore the fact that the person is under the influence if we don't know what drug they took before they left their house?
Well, there are a specific set of field sobriety tests for drug-induced OVI. That's part of my answer to your question is, and not all officers are trained in those separate tests, which the officer here admitted he was not. So I think the proper protocol would be to call someone on who is. The police can charge someone with anything. You know, the requirement is then can the state prove beyond a reasonable doubt at trial. So that's the phase that we're at, is did the officer have probable cause? You know, this isn't a suppression and erred in granting a motion to suppress. That would be what your issue would go to. This is the state failed to carry their burden at trial. The other part of that is that
Well, I mean, I guess this does go to another one of your assignments of error, but they did find a sticky note with meth on it.
right. And so that I think the sticky note is a bit of a red herring here. I can still dovetail to my answer to your prior question, is that it may seem odd to even this occurred to me when I was prepping for trial or for this argument, but you can drink and have one drink and then not be appreciably impaired, right? I don't have a lot of experience with meth, but I presume, or with marijuana, I guess any drug, you could probably take a little, whatever the portion is, take a little bit and still not be driving appreciably impaired. It's still illegal to ingest it. It's still illegal to possess it. But you have to link that to appreciable impairment, not just impairment. The law is appreciably impaired. So that's the other half of an OVI conviction, is appreciable impairment. And again, it would, yield probable cause. The sticky note, maybe it's another, they didn't know it had meth on it at the time. He just found it, said this seems like drugs. Possession does not, as we said in our brief, does not ipso facto mean ingestion. So that's the other part of that. But I still maintain that sticky note is a bit of a red herring. We know that it was in there. The specter of meth didn't come up at all. So we don't know if he was on it. We don't know how people act on meth. Things like hydrocodone, which is the Richardson case, marijuana, which is the Bowden case out of this, a lot of people have experience with that, even laymen. I know meth is getting worse, but it still is not something that even, criminal defense attorneys know everything about. So I would say that look at the case law that we cited in our brief. Even if there's these harebrained circumstances that you say, hey, I think he was impaired, that's only half the equation. So for example, we think that the Collins case is directly on point. That's out of the 9th District, discussed at length. And so this is a perfect example. There was a van that slid off a snowy roadway. The officer observed that the driver's speech was slurred and slow. His pupils were constricted. He was unsteady on his feet, no odor of alcohol. He felt that Mr. Collins was under the influence of something. And then there were failed field tests. Mr. Collins was convicted of OVI, but the 9th District reversed on these very grounds. And they said that while the revised code doesn't require them to prove specific blood concentration levels, it does, quote, require the state to do more than prove impairment in a vacuum. They held that the state did not establish a nexus between the impaired condition and any type of drug, and they reversed the conviction. There are similar cases. I'd love to find that other one. There was a case that they reversed where the guy was stopped in the middle of a road, blocking 2 lanes of traffic, pretending like he was driving and making noises like he was driving. Again, clearly something is up. They said, yes, there was evidence of impairment, but not evidence establishing that nexus. So I think that's what this case turns on, and this court can respectfully revisit Bowden, invoke the Richardson logic. Richardson also held that expert testimony was not required to forge that nexus, and we're not challenging that finding. We don't think that there is either. There just has to be some evidence elicited by the state to forge that nexus. If there are no further questions, I'll reserve the remainder of my time.
Thank you.
Thank you.
change up my order from how I did things moments ago. I'm going to start with the first issue, and that was the final appealable order. One, this court allowed the amendment of that to that issue is moot and isn't before this court. Additionally, I would point out that I believe that Daniels was a municipal court case in and of itself, and it was directly the same issue that was raised here. But like I said, that issue is moot. The court allowed the amendment. There is no issue as to final appealable order, and it's not necessary to rule on that. Jumping over to the reliance on Collins, the Collins court, yes, found there needed to be some nexus, but the Collins court also found very significant that there was no drug paraphernalia discovered in the vehicle. Here, sticky note with methamphetamine on it next to a mirror, which I don't know that there was specific testimony, but I think that is in the common knowledge that a mirror is frequently used for the ingestion of powdered narcotics. We have a marijuana pipe. Also significant in the presence of the sticky note with methamphetamine residue on it in the marijuana pipe is the fact that no marijuana and no methamphetamine was discovered in the vehicle, which I think can be interpreted that it was consumed. So we have, certainly evidence of drug usage. Mr. Fritz did make statements that, he had consumed alcohol. It's a bit confusing as to whether it was a couple hours prior, whether it was the prior day. There's some, much like his driving, there's some erratic nature in some of the statements that were made, and I don't believe that that's completely but he did make an admission to consumption when asked whether he was under the influence.
Admission to consumption is of a different substance
Yes, ma'am.
than the marijuana pipe or the methamphetamine in the sticky note.
Yes, ma'am.
So what's the significance of it?
So I would go back to and the primary basis for our argument in terms of some of like the relevance issues that weren't addressed so far today, but had been addressed in the brief, is that under 451119A1A, it's the state is obligated to prove that the defendant was appreciably impaired by the influence of either alcohol and/or drug abuse. And the argument that we're making, the argument that I believe we made below, is that it was a combination of all of these things that acted. I believe the term would be the synergistic effect. Now, nobody testified as to that. I'm throwing that in here. But the combination of the two working in conjunction is what robbed him of his ability to, appreciably impaired him, as demonstrated by the exceptionally bizarre behavior and driving that he was exhibiting, knowing full well that an officer's standing right behind him. Right there, he drives off through the park, driving around trees, driving around, I believe there was a greenhouse, and there's a bathroom, and there's playgrounds, and sirens going, and lights are going, and he just keeps cruising through the park. And so I think that there's obvious signs of impairment, and that our argument is that the combination of the drug paraphernalia that was found that can be interpreted as the recent ingestion of marijuana and methamphetamine combined with the consumption of alcohol, that those three things and whatever else was in his system, we don't know, but also going towards probable cause is the fact that the officer asked him to submit to a urine test because he believed he was under the influence of some drug. And that was his stated basis for asking for the urine test. And the refusal to take that test is evidence that can be accepted as a consciousness of guilt as to what those results would be. We combine those with and he didn't completely fail the field sobriety test. It wasn't 6 out of 6 clues on the HGN. I believe it was 3 out of 6 on the HGN. And the officer testified that he was not, I believe it was ARIDE, which is the advanced drug detection field sobriety tests, how that can be conducted, which is like vertical gaze, nystagmus, and those kind of things, and that he was not fluent in that, he had not been trained in that, which is why he asked the defendant to submit to the urinalysis.
Does that make a difference, the fact that he wasn't trained in that?
I don't, in terms of...
I mean, was he able to determine whether Mr. Fritz was impaired by a drug of abuse? Because as he was not trained in that, would he have the qualification to tell if he were impaired by a drug of abuse?
I believe that what that goes to would be the totality of the circumstances, and certainly had he had more advanced training and everything like that, that could have factored in. We have to take the witness as he was. Rum Witchebrung is the car racing terminology. He's the witness that we had. It does go into factor. Certainly, it would bolster our argument had he had that training. However, I do believe that he testified as to the number of OVI arrests that he had made, being in proximity, interacting with people who are impaired, and there was some of that testimony. So to the extent that, yeah, I'd love it. I mean, you know, if I were prosecuting this case, I would prefer that he had been and had conducted and put through those paces. I don't have that in this case, so it doesn't lessen what we do have, but it is less than what we could have had. I don't know if that actually answers your question or if I'm just rambling about that one.
No, I understand.
Yes, ma'am. I think I addressed in terms of Collins that it was significant that there was no contraband found. There's no paraphernalia found. We certainly have that here. Then coupled with I believe the court referred to it as bizarre driving and bizarre behavior that he was exhibiting. So we're not viewing it in a vacuum. There is a connection that is demonstrating. Now, and going back to Judge Bogg, I believe it was your question about if we don't know what they took. In terms of that scenario, and then coming across somebody who is obviously impaired, I would say that, one, we can't just willy-nilly, the officers can't just charge absent probable cause. That's illegal, and that can't happen. So there would have to be some sort of connection. If the level of impairment rises to the level of concern for that person's safety, perhaps they could call in EMS or something like that for an examination before letting it out. But I would agree with counsel that there needs to be some indication in there in order for there to be a connection between the drugs. Here we have that. We have the contraband. We have the sticky note, the marijuana pipe, admission to consumption, and his own statement that he was under the influence. And I think that while...
Well, his old statement was an amount that was consumed within a very broad amount of time.
Yes, and Your Honor, as
So I'm not sure that that's a statement that he's under the influence.
He specifically was asked if he was under the influence, and he said that he was. Whether there's some confusion as to what the officer meant or what a layperson would mean, if I've had a glass of wine and a police officer asks me, am I under the influence? Now, I think that anybody, my 18-year-old son, he shouldn't be drinking, but would know that that's meaning, are you feeling the effects of that? Not, have you had anything to drink is a very different question from, are you under the influence? And to say, are you under the influence implies, I am feeling the effects of whatever it is that I have ingested. And he has that admission. So I think when we couple all of it together...
So your argument, in essence, is that the officer was at liberty to take the response as it was provided?
Yes, ma'am. And the court and the trier of fact was allowed to ascribe to it whatever weight they wished on that. And in looking at the totality of the circumstances, we've got the performance on the field sobriety test, his inability to follow directions, the bizarre behavior standing on the truck, and the multiple interactions the officer had with him throughout the course of that afternoon, the exceptionally erratic driving, the presence of two different types of contraband, the admission to consumption, the admission to being under the influence. I think all of those factors made it reasonable for the court in a bench trial, for the court to find that he had been appreciably impaired by the influence of alcohol and or a combination with drugs of abuse. We haven't really touched on the evidentiary issues that were raised. If there are any questions as to the other assignments of error, I believe I've beaten this subject to death.
Thank
you,
you.
Your Honors.
So I'll start where counsel left off shortly ago. These purported admission to being under the influence, but again, point that the circumstances don't suggest Mr. Fritsch really knew what the officer meant. After he says that, but right before the one-leg stand, he says, "But I'm not drunk." So, I think he thought that it was an admission to maybe consuming something. We only have the admission he consumed 2 beers over a 24-hour period. And, my question would be,
I don't know that the state is using it as an admission. I think that they're using it more as information, the response.
I would respectfully disagree. I think they're leaning heavily on that as he was drunk. He said he was drunk. He was under the influence. And again, I don't think the average person necessarily is sophisticated enough to know what that means. And I'm wondering in this case, what is the state relying upon? Is it alcohol? Is it marijuana? Is it meth?
Well, their argument is all of the above.
All of the above, because they're reaching. So we would say that, and that is evidenced by the prosecutor at the close of in closing arguments. He said, he speculated maybe he took meth and alcohol, and that's why we don't have the usual physical effects. And counsel also referenced that theory. I would say that this synergistic effect theory would require expert testimony. We don't even know what the effects of meth are. That was not elicited at all. The average person may know what the effects of alcohol are, perhaps even marijuana, but pretty much nothing else. So we would say that this court should refrain from upholding that synergistic effect theory and discount that argument that you can say that these combined things should explain away the lack of physical
It
signs.
sounds like what you're saying is that the record does not establish the synergistic effect.
Correct. And it could very well be a valid theory, but a lay person wouldn't have the knowledge to testify to that effect, much less perhaps a police officer could who's well trained in drug consumption, but definitely the attorneys at trial can't be the ones bringing forth that as evidence, and we don't have that here at all.
Well, they would be bringing forth argument, not evidence. And
They would, but argument not grounded in the evidence.
Argument is not evidence.
Yes, I would think that would have warranted an objection, but, people have reasons for not doing things. And again, we would submit the record does support perhaps driving impaired. It's a weird set of facts, yes. That is only half the equation. I can't stress that enough. There has to be this connection to some alcohol or drug of abuse, and on this record, we don't have that. So we would, again, just defer to the cases in our brief that support that finding and urge this court to rule in line with those other courts of appeals and hold there must be something more.
So my question is this, with the record being absent on the effect of meth, okay, why wouldn't the bizarre behavior be sufficient to establish the OVI?
So we have to connect that, we do have...
I mean, along with the other stuff, of course.
Right. So we have to make some inferential leaps to get there. There was some evidence of these encounters earlier in the day that suggested that this client may have, mental health issues, being afraid of coyotes, standing on someone's car.
I was surprised no one brought that up in their arguments.
Right.
Thing, yeah.
The prior things when he was sitting, apparently scaring children, swinging or something. Like he was just, he could have had some issues that had nothing to do with any kind of consumption of anything. And we have to make an inferential leap that his driving through his park was the result of consumption. We have to infer that it was consumption of meth, which we have, again, no evidence of how someone even acts on meth. And then to connect what he's doing, oh, these are signs of meth, and he was clearly under the influence of meth at the time. Because again, I guess going back to the having one drink, I guess you can have one line or however people take meth and still be okay to drive. So there has to be, I urge the court to not just rest on the odd facts, to require, and I would argue that the Richardson case cited in Bowden, that prop of law does stand for the proposition that you need, they even said specific drug, connected to a specific drug. So if there are no further questions, we would just ask this court to reverse and discharge or remand for retrial.
Thank you. Thank you both for your arguments this morning. We will take the case under submission, issue you a timely decision, and we wish you both a wonderful afternoon. We're going to take a mild pause as we're changing the bench very quickly here.
Judge told me to stand up.
You didn't make the whole courtroom stand up.
Yeah, no, that's okay.
But I'll see what's up there.
You want to stand up?
Good morning.
Good morning.
Thank you for accommodating us. Obviously, this case hasn't been understaffed, or underattended.
Yeah. Well, let's take a pause as we get the courtroom settled in, and that way you can do your arguments without distractions. All righty, I think we're all settled in now. So this is case C220430436 in Re LES, ES, and NS. Counsel, whenever you're ready. So I think you've both have been informed that we're going to allot 20 minutes for each side. Yes? No?
Thank you, Your Honor.
You're both informed, yes?
I believe I'm just learning that now.
Okay, well then, we are allotting 20 minutes for each side. And I had asked for, keeping that in mind for each one of you to determine how much time you wanted to reserve. This is a cross-appeal case, so I'm going to give you a pause so that you can make that determination.
I'll reserve 5 minutes on my cross appeal, Your Honor.
Okay,
I'll reserve 6 minutes.
okay. All right, very good. So Attorney Durst, whenever you're ready.
Good morning, and may it please the court. I, Alex Durst, along with co-counsel Diana Link and Paul Courage, represent the appellant, Priya Shahani. We've obviously got a lot to talk about today with the cross appeal. There are 4 fundamental reasons why the court should rule in Ms. Shahani's favor. First, the equities do not favor Carmen. It's really not the type of case that it's, in our view, that it's been portrayed to be. Second, with respect to Ms. Shahani's appeal, the trial court made a very clear error by failing to apply the correct legal standard and instead applying a totally invented new legal standard that sidesteps parents' fundamental constitutional rights, or paramount constitutionally grounded parental rights. Third, Ms. Edmonds waived her argument that she's now making on appeal. She made a very different argument in the trial court, and it's a totally new argument on appeal. that the court cannot consider. Even if the court were to look past that, the facts and the law don't support the legal theories that Ms. Edmonds is pursuing. And 4, the court failed to afford extreme deference to Ms. Shahani's wishes as the children's parent when fashioning the Companionship Time Award. Now, this is a same-sex custody case, and one thing we really want to make clear is that our client, Ms. Shahani, is not attempting to sever the connection between Ms. Edmonds and the children. A lot of times in same-sex custody cases, there's this insinuation that the mother is, using the law as a weapon. That's absolutely not the case. Ms. Shahani, to her credit, no matter how bad things got between her and Ms. Edmonds, and even in the aftermath of their breakup, when she was somewhat in fear of Ms. Edmonds and there were a lot of ugly issues, she never stopped the children, or never prevented Ms. Edmonds from being able to see the children. And the magistrate recognized that in this case. The issue in this case is not trying to use the law as a weapon to just cut somebody out of children's lives. The issue is that Ms. Shahani respectfully has a different view about the appropriate amount of time for the children should spend with Ms. Shahani and Ms. Edmonds.
Counsel, what is that amount of time?
I believe that what Ms. Shahani was advocating for in the juvenile court was a schedule that approximated, it was roughly every other weekend.
And so if the juvenile court had ordered an every other weekend companionship schedule, we wouldn't be having this appeal?
If the juvenile court had applied the proper legal standard, we believe that that result would have been reached and our third assignment of error would not be before the court.
What is Carmen's legal relationship to the children?
Well, her legal relationship to the children is a non-parent seeking companionship time, which is actually one thing that the trial court got right, as we see it. I mean, she's not a parent. And so, yeah, that's what her relationship is to the children.
What is your position with regard to the applicability and the effect of Obergefell?
Okay, so we really do not believe that at its core, this is a case that has a whole lot to do with Obergefell. In our view, we should only be discussing Obergefell as it relates to whether Obergefell impacts in some way Inree Bonfield, which addresses shared custody agreements between a parent and non-parent, or Inree Mullen. Because the question is, does Obergefell somehow impact that analysis such that the trial court should have followed?
So let's talk about that, because the trial court ultimately treated it as if Obergefell just did not impact that at all. So based on what you just said, it sounds like what would be appropriate, if I agreed with what you said, is to remand it for the trial court to consider the impact and effect of Obergefell.
So it's complicated because there are multiple assignments of error, and ultimately a remand to consider the matters under the right standard could well be the ultimate result. In our view, though, the judge did consider Obergefell, we believe, because in the December 5th, 2019 temporary order, the judge explicitly addresses Obergefell and says, now Obergefell's been decided, and we've got to address, Obergefell confers the right to same-sex marriage and maybe certain other benefits, and we've got to consider what its impact is. And then the court went on to create this totally new legal standard, which is instead of the Inree Mullen standard, which respects the paramount constitutionally grounded parental rights to the care, custody, and control of children.
But that was a consideration that was independent of Obergefell, was it not? At that point. So even though there was a discussion of Obergefell, when it came to the analysis part of the decision, that the analysis that the court then engaged in was independent of Obergefell.
There is some.
I'm asking you.
We don't believe so. We believe that what the court did was the court took this standard that it created, supposedly based on Obergefell, substituted that test or legal standard for the legal standard that Inri Mullins supplies.
But the court actually articulates in their judgment that they have no guidance and they haven't been told otherwise to apply Obergefell. And then they went on to render a decision with regard to rights, custodial rights, and then ultimately, allotting parenting time.
Well, it appears to us.
So basically, the court applied Mullins as it stood pre-Obergefell, did it not?
No, absolutely not. So for one, the court does not mention Obergefell in the August 5th, the ultimate judgment entry that's being appealed. The court only mentions Obergefell one time, and it's in connection with rejecting Ms. Edmonds' parentage argument. Now, in addition, and this is, one of the fundamental problems of what the trial court did, under Inri Mullin, the most important factor, which really it's dispositive, is whether the mother whether the mother refuses to sign a shared custody agreement, despite knowing that it's an option. So, put a little bit more eloquently, what Inri Mullin says is that if a mother is aware that one of these shared custody agreements is a legal vehicle to confer custody to her same-sex partner, yet refuses, especially repeatedly, to sign such an agreement, that is the best evidence of whether custody was voluntarily relinquished, which is the test under Inri Mullin. And now, what's significant, what's one of the most important things here is that the magistrate considered that, and that was really the basis for why he concluded that there was no voluntary relinquishment, there can't be shared custody, there was no shared custody agreement created. The judge accepted the magistrate's factual findings, but then the judge applied, it appears the judge applied her own test that she basically made up in the December 5th, 2019 entry. And
well,
nowhere...
the trial court didn't find shared custody as to the twins, right? I mean, she just ordered companionship time.
That is our view of it, because in the part of the entry where it says, based on the foregoing analysis, I order X, Y, and Z, it does not say anywhere shared custody of ES and NS, the younger children, the twins, is awarded. Just companionship is awarded, which wouldn't be consistent with shared custody. So in our view, shared custody was not ordered. And, part of the relief that we're seeking, depending on how the court comes out on the issues, is some recognition of that in the Court of Appeals decision. So we don't believe that she ordered it. I will tell you, I envision Mr. Hilton will tell you that in Ms. Edmonds' view, that they believe the judge did order shared custody of the twins. And that's an issue that, not that's in the appellate record, but it's causing issues between the parties. But so our position is, the way I think we phrased it in our brief is, to the extent the juvenile court found that there was a shared custody agreement regarding the two younger children, that finding is error. We still don't believe the decision is granting shared custody.
I'm going to go back, because I'm not sure that I understood your answer, okay?
Mm-hmm.
Did the court consider Obergefell? And I heard you say you believe that the court did.
I don't believe...
The ultimate decision, and if so, and if you're saying yes, then how? Because how will I find that in the entry?
So to Judge Powers' credit, she did, well, both the magistrate and the judge rejected Ms. Edmonds' parentage argument. So they appropriately considered Obergefell in the sense that they determined that, under Ohio law, Ms. Edmonds can't be deemed a parent by the court.
So you're basically saying by inference, is that what I'm understanding from your argument?
Yes. And, in fairness, the argument that Ms. Edmonds was making about parentage was a lot more vague and just kind of throwing out buzzwords, Obergefell, equal protection, but it was a little disjointed. But by implication, it would appear that, I think we can deduce and we can assume that the judge and the magistrate, neither of them interpreted Obergefell as giving them the ability to award parentage to Ms. Edmonds. But with...
Well, Mr. Durst, let me follow up on that with you because I understand the issue about the definition of parent in Ohio. Just, if you will, just assume all the facts and circumstances in this case and apply it to a heterosexual couple. Would the results have been different?
We could have a very long discussion about that with different hypotheticals. What we have here is a same-sex couple that would never have been married even if it had been legal. There's dispute about that. There's not a lot of evidence in the record.
That's an issue of fact. So that's not something that we should be determining. Would you agree with that?
Well, I don't believe the court should be...
There's a lot of argument in the briefs about whether they should have been married, whether they would have or not have, but ultimately that is an issue of fact that the trial court didn't make.
Well, we don't believe that there are several issues that these questions touch on.
And I kind of, if you can go back to answer Judge Winkler's questions, I didn't mean to.
Well, yeah, and your question is something I was planning to directly address. So, okay, so if this had been a heterosexual couple that had been unmarried and the woman became pregnant through ART, but with donor sperm, then the male partner would be in the very same position as Carmen, because as I see it, I don't see any way under the Ohio Revised Code. The adoption laws may have changed between now and then, so if there's something new with adoption, then that would, it would help a same-sex partner and a different sex partner. But barring that, at the time, of the events in this case, the analysis would have been the same. The woman would be the child's only parent. And
Counsel, the basis for your answer is because Ohio law defines parentage on the basis of marriage, right?
Well, it defines parentage on the basis of a biological link, biological connection, or adoption.
And if you are the non-biological parent, the only other pathways exist through marriage.
I believe there may be a pathway through adoption, though, Ms. Edmonds would not have been able to adopt.
And so to look at the marriage pathway to parentage, we must consider who is eligible to be married and who is not, and what constitutional ramifications exist for that right. Can you respond to that?
Well, let me back up a minute to answer your question in a little bit more detail. When you say that marriage provides an avenue to parenthood, the only way that it does is through Ohio's ART statute. Now, in the trial court, let me back up. That is the argument that Ms. Edmonds is making on appeal. Her argument is Obergefell requires certain statutes to be read gender neutrally, which we're not vehemently opposing, and that in addition to that, under the ART statute, 3111.95A, Ms. Edmonds would have been the children's parent if same-sex marriage had been legal at the time. Now, there are additional issues. There are a number of deficiencies in that argument, including issues just related to the ART statute. Before getting into that, though, it depends on a would have been married standard being adopted to go back and, I mean, in our view, force our client into a marriage that she would not have entered into.
And I don't. That's something you argue that I'm not understanding, because it would only be it's not forced because it's an issue of fact that the trial court would have to consider and would have to determine on the evidence whether the evidence established that the couple, meaning both parties, would have entered into the marriage but for Ohio's ban for same-gender marriages.
So I would be remiss not to point out that that argument was never raised in the trial court, and it can't be considered on appeal. The court does not need to reach a decision on that admittedly complicated issue.
But I find it interesting that in your client's objections, it's acknowledged. So in the discussion of Obergefell, your client states Carmen's arguments implies through, though does not expressly state that her goal is to stretch the holding of Obergefell to include those individuals who would have married but could not have because Obergefell had not yet been decided. So it was recognized by your client as being a central point of Ms. Edmonds' arguments.
So it was not, that you read the language correctly. Let me back up to give you a thorough answer of why there was a clear waiver in this case. So I'm going to read to you, it's very short, Ms. Edmonds' argument that was stated in her closing argument. Before doing that, let me
I'm familiar
reiterate.
with that. I've read that and I've looked at it very closely, but you're welcome to read it.
Well, so basically she argued that a same-sex partner of a person who conceives a child through artificial reproductive technology may establish a legal fiction of biological parentage by asserting the presumption of paternity outlined in 3111.03A3. So on appeal, she's saying that RC 3111.95A is what confers parentage. So even if you generously, as we would see it, believe that the would have been married standard was argued, they still would have had to argue at the trial court level that 3111.95A provided a path to parentage, which, I mean, we don't think it does for other reasons. But that argument, that statute was never cited in any of the 100 pages of briefing. It wasn't mentioned in the transcript, not in closing arguments. And even more importantly,
But that brings me then all the way back to my first question, and let me explain. So my first question is, did the trial court consider the effect of Obergefell at all? And that's a broad question. You're right now talking about a specific statute and Obergefell's effect on that specific statutory section and that not being raised. But you still have to get to the hurdle or the discussion or the determination as to whether Obergefell applies at all before you get down into the statutes. So I go back to that central question. Did the trial court consider Obergefell's impact and effect at all? Because that was being argued, whether it was artful or inartful, whether it was specific to statutes or not, that was being argued.
well, Ms. Edmonds did mention Obergefell in her arguments. We think it's clear that the trial court did consider Obergefell because the trial court cites to Obergefell. The magistrate does, and the judge does. So that tells me that the judge and magistrate did consider it. And with respect to parentage and those arguments, they correctly determined that Obergefell, you can't connect any dots from Obergefell to what Ms. Edmonds was arguing. to make her a parent under Ohio law.
Counsel, there's another case that I think does connect those dots that we're maybe skipping over. And could you address its applicability for me? It's Pavin v. Smith. So it seems like the Supreme Court itself has talked about the application of Obergefell to parentage under state law by saying that state laws that define parentage by marriage have to do so by recognizing the fundamental right to marry for same-sex couples. How does that work, either for or against Ms. Shahani?
So it does not work against Ms. Shahani because what Pavin boils down to is statutes have to be read gender neutrally. It's not really about it's marriage-related statutes, and statutes that confer rights based on marriage have to be read gender neutrally. So if it says spouse, or if it says husband, it could be changed. It should be read as spouse. However, that case had to do with a birth certificate and a couple that had gotten married in another jurisdiction where it was legal. You would still have to even if you read Ohio's statutes gender neutrally, you have to you have to apply that to 3111.95A. Which there are other issues with it, even if you do, and even if the issue had been raised. But Ms. Edmonds never raised that argument. Her argument in the trial court was about this legal fiction under 3111.03A3. So that's the argument that Ms. Shahani, came prepared to address. And now, on appeal, there's no mention of that statute. That argument is totally abandoned. And it's shifted to an argument that is based on 3111.95A. And that statute was never raised. They will not be able to show you anywhere in the hundreds or thousands of pages of briefing or in the transcript where that statute was so much as mentioned. If the statute wasn't mentioned, the argument was not waived. And the court can't just consider on appeal a totally new argument that we didn't show up at trial ready to defend
your
against.
Position that Ms. Edmonds is raising a statutory argument and not a constitutional one, and that statutory argument was not preserved?
So let me be clear. Ms. Edmonds made a constitutional argument at trial. She threw in Obergefell, and she made a statutory argument about 3111.03. But she didn't make the constitutional argument that's being made on appeal. Because if you take away 3111.95A, if you're as generous to Ms. Shahani, to Ms. Edmonds as the court could possibly be, their argument depends on 3111.95. And that part of the argument, at a minimum, was not raised in juvenile court. I mean, so if you take, at the risk of being dramatic or theatrical or histrionic, if you look at Carmen's objections to the magistrate's decision, that is the most important document for the waiver analysis, and it respectfully ends the analysis because the Ohio civil rules, the specific one is stated in our brief, state that to preserve an argument for appeal, you have to raise it in objections to a magistrate's decision. And if you look at their magistrate's decision, at Ms. Edmonds' objections to the magistrate's decision, nowhere in there does it say the parties would have been married had it been legal. And, and also dispositively, maybe more dispositively, it does not say in there that 3111.95A provides a route to parentage, and we satisfy the requirements of that statute, so it should be read in a way that makes Carmen a parent. That argument was just plainly not raised.
So what is the argument that Ms. Edmonds did preserve for this court?
The argument that she did preserve is that it's on pages, bottom of page 3 through page 5. Her argument was under the other provisions of Chapter 3111. So it was about the legal fiction of parentage that she was requesting in her closing argument. So she refers to her closing argument, and that's what I read to you, and what you've read, that requests this legal fiction under 3111.03A3. That's the argument in here. I mean, nowhere in here does it say 3111.95A or even allude to anything related to that argument. That's a new argument that was made on appeal for the first time.
All right, so she is claiming some statutory pathway to parentage. It's just not the statutory pathway she's claiming now. Is that your position?
Arguably, I mean, she was claiming a materially different statutory pathway under a different statute. So to me, I mean, whether it's statutory or non-statutory, the argument that's before the court now, 3111.95A, was not the argument that was made before. I mean, because the case law says, and I know a case that says this is cited somewhere in our brief, that it's insufficient to raise an argument in a skeletal way, leaving the court to put flesh on its bones. Here, you don't even have the skeleton because you don't have any reference to 3111.95A, much less an argument for why it applies. So it's not enough to say that, okay, Obergefell means I should be a parent, and then the juvenile court judge is supposed to, even though nobody's making the argument, basically do the research for the party, find that argument, and analyze that argument. And much less would it be plain error for the juvenile court to not make that, or to not rule on that argument. I mean, it can't be plain error for a whole host of reasons.
Unless there's any other questions, I'll reserve your time.
Thank you.
Thank you.
Good morning, Your Honors. Jonathan Hilton for Ms. Carmen Edmonds. May it please the court. I want to start by addressing custody first, and then we'll move on to parentage. I want to give you 4 places in the trial court's decision below where she found custody for all 3 children, including the twins. Because I know that there's been confusion and debate between both sides of the aisle as to what the trial court's order means, so I just want to clarify that the trial court did find shared custody for the twins. The first place that I want to direct your attention to is on page 3 of the trial court's decision. And I want to read you a quote. The trial court says, although the court finds that the magistrate did not err in not ordering shared parenting, a review of the record does indicate a shared custody agreement existed for all 3 children. So, the trial court does review that magistrate's finding of no shared custody for the twins and does state here that it is going to modify the judicial entry. Moving on to page 4.
Is there a reason that the trial court did not consider the testimony that Ms. Shahani rejected a shared custody agreement for the twins?
Yes, Your Honor. If you look to page 4 of the trial court's opinion, the trial court states that it is basing its decision on shared custody over the twins and over all 3 children on the documents, the documentary evidence in this case. And I have here those documents. They were introduced as exhibits 2, 3, and 4 by Ms. Edmonds below. It's a living will that Ms. Shahani signed, together with her health care power of attorney and her last will and testament. And
Weren't those documents revoked, though?
They were revoked, but much later, and I'll read you the exact passage that deals with revocation. She says in her living will, I consider Carmen T. Edmonds as my children's co-parent / co-custodian. And I have an agreement to have and raise the children subject to this POA as equal co-custodians. This document is evidence of that agreement. This document, even if subsequently revoked, is evidence that I have ceded exclusive custody in favor of shared custody with Carmen T. Edmonds. So the later revocation is irrelevant to what her intentions were in the hospital as the twins were being born. So the trial court states on page 4 that she is relying on the documents, the living will, in order to make the shared custody determination and to find shared custody over all 3 children. And that's why she's modifying the judicial entry. The trial court again says that there is shared custody for all 3 children on page 11. And on page 11, the trial court says that the trial court finds that shared custody is in the best interests of all 3 children. So the trial court would have had no reason to find shared custody in the best interests of all 3 children if the trial court had not been deciding that there was shared custody over the twins. And finally, the 4th place is on page 15, when the trial court states unequivocally that the magistrate did not correctly apply the law, and that's the law of In re Mullen and In re Bonfield, which the trial court relied on, did not appropriately apply the law to the facts. And if you look at the magistrate's opinion, you will see that that determination of no shared custody over the twins, what the trial court was modifying, you'll see that that was under the analysis portion. It wasn't a factual finding. While technically speaking, we might think of it as a factual finding, it was under the analysis portion of the magistrate's decision. So the trial court is modifying the magistrate's judicial entry in order to give shared custody for all 3 children. I agree with what my friend said on the other side, that no matter what the result is here, it would be useful to the parties to have this court clarify the meaning of the trial court's order. But I believe that the trial court's order is unequivocal in ordering shared custody. With that, I'll turn to the parentage issue unless anyone has any further questions on shared custody. I'd like to turn to Judge Winkler's question first, which is the question of how does the would have married standard treat the individuals in same-sex couples versus opposite-sex couples. And the standard that we are advocating for here meets equal protection because it asks the same question of all couples, whether they're same-sex or whether they're opposite-sex. The question is, were they committed enough to marry? And in the case of an opposite-sex couple, we know, because if they were committed enough to marry, they would have done so. They went out and they got that marriage license and they had the ceremony. In this case, we also know that the same-sex couple here was committed enough to marry. They exchanged rings. They made promises.
Those are arguments that are best preserved for the trial court, wouldn't you agree? I don't think you're asking us to make that determination a fact.
Your Honor, the record is sufficiently clear here that you could make that decision and you could make that finding because it's 100% to 0 in terms of the evidence in the trial record.
But isn't that a finding of fact for the trial court to make? And the trial court did not make any determination with regard to Obergefell?
It's true that the trial court did not make that determination. I believe that this court can make the determination on the record because there's no evidence in the record for the position that the other side is advocating.
Well, there is evidence to indicate that Ms. Shahani would not have married Ms. Edmonds. In fact, her sister testified that she had made a comment to that effect at some point. So there is mixed evidence in the record.
Your Honor, the 2 pieces of evidence on which the other side relies, one was a statement from deposition that Ms. Shahani did not introduce at trial. But the second is a comment by Ms. Shahani's sister, Maya Shahani, that she believes that at some point Priya may have said to their older sister that, no, I'm not going to marry Carmen. Even if everything in there is true, and there's nothing in the record that would support a finding that the statement was based on any personal knowledge, but even if Ms. Shahani at some point had said that, the reason that she wasn't going to marry was because they traveled to Boston and they realized that Ohio's same-sex marriage ban, which eventually was ruled unconstitutional, but at the time was the law, prevented them from marrying.
Well,
So-
let me follow up on that. Had they gone ahead and been married in Boston, then came back to Ohio, wouldn't that marriage have been recognized in Ohio under full faith and credit?
Eventually, Your Honor.
Well, wouldn't it, it seems to me it would have automatically been, at least constitutionally, because my recollection, understanding is that is what was happening, is you go to a state where you can get married, come back to Ohio, it's recognized, which is great. But the indication that they decided not to get married, isn't that strong evidence that there was no intent ever to marry?
Your Honor, I think that it is evidence of their intent to marry. And
By not getting married?
Yes, Your Honor,
Okay.
because the fact that they took the trip, and the fact that the only
Yeah,
reason,
It could have been going to see a Red Sox game, too.
Your Honor, the only evidence and the only testimony that is in the record is my client's testimony on the Boston trip. And she states in her testimony that they went to Boston to get married, and that the only reason that they didn't go through with it is because it had no point in Ohio.
Counsel-
Their belief, that was their belief.
Which was the law of Ohio at the time. The Ohio same-sex marriage ban stated specifically that it was against Ohio's strong public policy to recognize any out-of-state
That's
marriage.
unconstitutional, right?
Yes, Your
I'm
Honor.
gonna stop. You keep
Yes,
going.
yes, Your Honor.
Move
It is
on.
unconstitutional.
Right.
I agree.
Counsel, in looking backwards and attempting to assess the behavior and choices of people who at that time didn't really have these choices because the law of the state of Ohio prohibited them from making these choices, what guideposts should we look at? What would have been evidence that a same-sex couple would have wanted to marry at a time when the law prohibited them from doing so?
Your Honor, the best list of factors that I have found is cited in a Court of Appeals case from Oregon called In Re Partnership of Madrone. That's cited in my opening brief along with Oklahoma Supreme Court decision Ramey versus Sutton, which also addresses some of these issues.
Are those common law states?
Your Honor, there's no they are not determined based on common law
I understand
marriage.
that, but are they common law states?
That I don't know. I'd have to read the opinion more to refresh my recollection of that, but I don't know whether they're common law or statutory. But I can tell you that they're not cases in which the court retroactively found a common law marriage. And I know that because I found those cases, but I did not cite them here for specifically that reason. I didn't want to confuse that issue since Ohio doesn't recognize common law marriage. As for the guideposts, In Re Partnership of Madrone says that this is a routine kind of factual finding that trial courts make all the time, and that you want to look to whether the parties exchanged rings. You want to look to what they said and they did in their actions, whether they held each other out as partner, or, as in this case, whether they attempted to marry, but ultimately that fell through. So looking at those factors that are spelled out in the In Re Partnership of Madrone case, on this record, there's only one way that this case could go, and that's that the parties would have been married. They hyphenated their children's last names. That's not the kind of thing that you do if you don't consider yourself a family, if you're not married. Boyfriends and girlfriends aren't hyphenating their last names. That's something that you do when you're raising children together. You're forming a family, which is what the Constitution protects.
I'm going to ask you the same question that I asked Attorney Durst, and that is, what was the trial court's handling of Obergefell? Did the trial court consider its impact and effect?
Your Honor, the trial court considered Obergefell only insofar as the trial court made a determination that Obergefell did not overturn or abrogate In re Mullen. That's what the trial court said that the trial court was doing. The trial court said nothing in that case overturns the existing statutory framework. But my counterpoint to that is that the trial court was asking the wrong question. In re Mullen and In re Bonfield never considered a due process challenge. And and I don't mean to go into the realm of
Well, it
conjecture.
sounds like there's two issues. I mean, obviously, that wasn't at stake there, so they would not have considered it, right?
Exactly.
Secondly, those cases are not parentage cases, and, your position was a constitutional argument with regard to parentage. So perhaps I'm asking the wrong question. Perhaps the question I should be asking is whether the trial court had considered Obergefell with regard to your presentation of parentage rights to your client.
Your Honor, the way that we presented this to the trial court below is we used the words that Ms. Edmonds was unconstitutionally prohibited from establishing parentage, quote, via the marriage contract, unquote. Now, to go to my friend's point, I admit that what we've said here is somewhat pithier. And in fact, the language that we're using in this appeal, we got out of their response brief, because I agree that it is pithier. But it is the same basic argument.
I mean, looking at your complaint, this is how I understood your complaint. I understood your complaint because that's where I started.
Yes,
right?
Your Honor,
So-
and the
So
complaint...
I understood your complaint as saying that, that there was parentage rights as to your clients, and that it came pursuant to their intent and sort of their behavior. Now, when you got to your written closing arguments, you seem to continue with that and maybe fine-tune it a little bit, and then when you got to objections, then it, but ultimately, the central question of constitutional effect of Obergefell, while you were positioning it in a specific way as to a statute or whether it's on intent and behavior, I'm going to rephrase my question that I've been asking, and I'm going to ask it again now. Did the trial court consider Obergefell's impact and effect with regard to parentage?
No, Your Honor, because the trial court believed that In re Mullen was a bar.
Is your client
So
raising?
if I could?
Sure.
Okay. So what would be your response to this court then remanding the case for the trial court to consider Obergefell, which is a separate and apart question to what is the test or standard to be placed, or whether the would have married determination, separate and apart to that? What would be your position on a remand for Obergefell to be considered, whether the impact and the effect on parentage?
Your Honor, I'll read you a line from the trial court's decision that I think best reflects the extent to which the trial court did consider it, and I'll link that in and talk about whether the case should or should not be remanded. This is a line from page 3 of the trial court's opinion. The trial court, after discussing Obergefell, and after on page 2, recognizing that at no point during the parties' relationship...
This is the judicial entry?
Yes, Your Honor, it was...
Page 3?
Page 3. The trial court says, there is simply no statute or holding from a higher court that explicitly or implicitly authorizes this court to determine Miss Edmonds is a parent to the children. And I read that as the trial court saying that it is deferring to this court or the Supreme Court of Ohio as higher courts to interpret Obergefell. And I read it...
Well, I think it'd also be read that everyone has been silent on it And so, because there's no discussion, the trial court doesn't seem to feel at purview to make a constitutional determination. So the problem there is, and I think this is where you're going, is unless it's premised on the trial court does not have authority to make constitutional determinations, I don't think you want to be saying that, then I'd like to go back to my question on remand.
Yes, Your Honor. So in terms of a remand, there are advantages to that outcome because we would have the opportunity, and both sides would have the opportunity to make these more developed arguments and to really, this court could impress upon the trial court the need to fully consider Obergefell. So there are advantages. In terms of does this court have the power to rule on the record as it stands? I would say yes.
But here's a question to follow up on that position. Should this court be considering whether both sides truly had the opportunity to fully vet this out with the record that we have at hand, and thus forge forward with the record versus remanding it for the trial court to consider the impact and effect of Obergefell, and then open up the opportunity for it to be fully vetted out and for both parties to have a full opportunity of presentation? Because if you're asking us to determine it, then we would be making a determination that both parties had full opportunity, and on this record, we should move forward.
The reason that I believe the other side in this case had every opportunity to put more evidence in the trial record is because if you look at Ms. Shahani's opening statement, Ms. Shahani's attorney says in her opening statement that the evidence that they will present will show that Ms. Shahani never would have married Ms. Carmans. So they knew from the start that this was something that was going to be brought up at trial, and they simply failed to amass the evidence that would move the needle even to having any competent, credible evidence in their favor.
But wouldn't it be fundamentally unfair to disallow Ms. Shahani to make that presentation, whether she, in fact, would have married, and for us to just, again, forge forward with the record as we have it?
Your Honor, our complaint gave fair notice that we were raising Pavin versus Smith. We cited the case. In our opening statement, we made clear and unequivocal statements that we were relying on the court's equitable powers to afford parentage here because our client had been denied a fundamental constitutional right to marry.
In your closing statements, did you discuss the should have married standard? Or this, not standard, but the inquiry?
Your Honor, not at length. The closing statement, which is after all of the evidence was amassed, but the closing statement referred specifically to her lack of ability to establish parentage via the marriage contract. So it was a short point, and it was one of many points. It was a short point, and it was one of many points. But that's all we needed to preserve the argument for appeal, and that doesn't relate to whether the other side had a fair chance at trial to adduce their evidence.
I hope you can agree that there's a difference between preserving a constitutional argument and preserving the test to be afforded and the determination of fact.
Your Honor,
you can agree with that.
There is, although I will say that the other side did insert that standard, and the core of our argument is there. All I'm doing here is adopting that pithier statement that the other side introduced about would have married, and building my argument on what the trial court must have considered, given that it read all the necessary transcripts, that's on page 1, and then read both sides' concluding arguments in light of the record.
Unless there's any other questions.
I have one additional question, and I just want to make sure that I understand. Is your client raising a constitutional argument, a statutory argument, or both?
A constitutional argument, Your Honor. I think the confusion comes from the fact that in my brief, I was specific in bringing up the artificial insemination statute, and where we've seen these waiver arguments go is just that I was very thorough in bringing that up, when in the trial court, everyone understood and assumed that if these parties had been married, then there was a route to establish parentage. So in terms of did the trial counsel below cite some specific statute? No, but they didn't need to. The trial court knew and the other side knew that if a married couple has a child and they decide to have a child through artificial insemination, then both of the married partners are parents of the child. That's not an unfamiliar proposition, and it was fair for all parties below to assume some background knowledge that that's how it works.
Thank you.
Thank you, Your Honor.
I'll be reserving your time.
Thank you.
I want to correct something that was just stated. There was not a shared assumption at the trial court level that had the parties been married, that there would have been a route to Ms. Edmonds obtaining parentage. So their argument was under the 3111.03 statute, and that is the statute that has to do with this affidavit of paternity that can be filed. And admittedly, I'm going off of memory because this argument is not being made at all on appeal. What Ms. Shahani's trial counsel argued was she pointed out 4 or 5 reasons why, under that statute, there's not a route to parentage. And a lot of it had nothing to do with marriage.
So it sounds like that's separate and apart as to the impact and the effect of the Obergefell on parentage. And then you get to the statutes, and then you see which statutes may or may not apply.
It's part and parcel of Obergefell, because they told you they made a constitutional argument, not a statutory argument, at the trial level. So they were arguing that because of Obergefell, it's very clear in their complaint and everywhere. They say because of Obergefell, 3111.03a gives us the right to parentage. Here is where the confusion is coming in. So,
Well,
Ms.
at one
Link,
point, I believe they said 31.01, 0.01 to 0.18. They cited like a whole section of statutes.
well, just the one, the .18.
Well, the complaint references a cluster,
Yeah.
3111.01 to .99, or some large cluster of statutes.
I would have to look at the complaint, but, I mean, you could cite to the entire Ohio Revised Code. That wouldn't preserve an argument that
Well,
under
I mean,
this specific
well,
statute.
but the argument was parentage, that Obergefell, is now, that Obergefell was impacting and affecting parentage rights for same-sex couples. Now, whether that applies to this case, that's a factual determination to be decided.
Well, it's partly a legal determination.
Well, yes.
And that legal determination was made. So I want to give you a better answer to your question than you received from me previously, and I would submit from my friend on the other side.
That's okay.
So to remove any doubt that the trial court did consider Obergefell in connection with this argument, at the bottom of page 3, it states, the judge, in the August 5th, 2022 decisions being appealed, the magistrate correctly found that In re Mullen bars this court from issuing a finding that Ms. Edmonds is a legal parent under the current statutes of the state of Ohio. Ms. Edmonds cites to multiple sections of the revised code and the United States Supreme Court's decision in Obergefell versus Hodges to argue there exists a pathway to determine Ms. Edmonds is legally a parent. However, The court finds this argument unpersuasive. The significance of that is that, for one, the court considered Obergefell explicitly and clearly. Two, in fairness to the trial court ruled on the argument that Ms. Edmonds was making under Obergefell. And that argument didn't have anything to do with 3111.95A. And I'm going to go back again to the rule that says you have to clearly elucidate an issue in objections to a magistrate's decision in order to preserve it for appellate review. And all you have to do is go to Carmen's objection, and nowhere does it say the magistrate is wrong because under 3111.95A, we have this route to parentage.
Counsel, the trial court assumed, based on what you just read, that Obergefell did not disturb the Mullen framework. But let's assume for a minute that the trial court were to say Obergefell shifts Mullen, and that necessarily involves inquiring whether two parties, Ms. Shahani and Ms. Edmonds, or any future two parties, would have married each other. And I recognize the difficult place that this puts both courts and people in, to look backwards and analyze what would have happened hypothetically in a relationship that has now ended and that was never possible in the first place because the law unfairly barred these parties from even considering whether they would marry each other. What factors should a court look to determine whether two parties would have gotten married to each other at a time when the law barred it?
Well, I don't think the court needs to reach that determination because the issue was not preserved for appeal. I will answer the question, though. It's a very hard question to answer. And as we see it, the remedy for the violation of one person's constitutional rights should not be to remove constitutional rights from another person and say that, that Priya would have married Carmen when Priya did not want to marry Carmen. I mean, it's forcing Priya into a situation where there are rights that are being lost against her will. That can't be the answer.
So is it a simple statement by one party or the other now that I would not have married then? Does that end the inquiry?
I think the court should look to, in this case, the fact, well, first of all, the testimony about the trip to Massachusetts, if this is remanded, that testimony will be shown to be wildly inaccurate and arguably perjurious based on what our client has told us, because there's no elucidation about that in the record. But by Ms. Edmonds' own claim, the parties traveled to a state where same-sex marriage was legal in order to get married and then decided not to. So deciding not to get married is the best evidence that someone would not have been married. Just like refusing to sign a shared custody agreement is the best evidence that a party is not ceding custody to a non-parent. The word is no, and the conduct is refusing to sign a shared custody agreement. Just like, the conduct was allegedly traveling to Massachusetts and then deciding not to marry. So I think that fact alone would preclude, just the minimal evidence that's in the record, that admission by Ms. Edmonds is enough to preclude any finding of a would have been married in this case, which I think, I think prevents this court from needing to engage in that analysis, because even if that standard would be proper, which it wouldn't be for a lot of reasons, and it wasn't preserved, then it would be unavailing to Ms. Edmonds in this case. That's why, we really don't think this is a case about marriage. It's a same-sex custody. I won't even say that. It's a dispute between a parent and a non-parent that's governed by In re Mullen. And I'm sure I'm nearing the end of my time, and so I want to address that quickly. Bonfield and Mullen are not impacted by Obergefell. After Obergefell, same-sex couples can now marry if they want to marry. And if they do marry, they're not subject to In re Mullen or In re Bonfield. Those statutes apply to an unmarried couple where one of the partners is not the biological partner of the child. So it would apply to same-sex couples and different sex couples alike, both Bonfield and so Obergefell just says that marriage, that those couples have the right to marry. So in our view, Obergefell and Bonfield are not Bonfield and In re Mullen are not impacted by Obergefell.
In your view, does Obergefell impact the parenting statutes?
Yes.
I mean, you have to look into the details, but
So Obergefell, it allows two people to marry. If they marry and they have children together, then...
let me ask the question differently. Some of the Supreme Court precedent refers to it as the retroactive effect. In your position, does Obergefell have a retroactive effect on parentage statutes?
I think it might depend on the statute, because when courts are in the difficult position of remedying a constitutional violation, it's not always possible to put the toothpaste back in the tube, and there's very extensive analysis that has to be done. So I think it's going to depend on the statute. However, after Obergefell, a same-sex couple that had children prior to 2015 could marry now. And so this
Sure.
all of...
The quirk here is that you have a couple that had basically separated before Obergefell was pronounced.
A couple that decided to not marry and then separated before Obergefell was announced, yes. So unless there are other questions, we respectfully ask that you find in favor of the appellant. Thank you.
Thank you.
Your Honors, I'll say one more thing about waiver. There were a number of statutes that trial counsel cited below. But one thing that I want to emphasize, and that I don't think is in dispute, is that one thing trial court argued in its closing and in its objections to the magistrate was that there is a catch-all provision in Ohio's paternity statutes. And that paternity provision says that the trial court can consider any evidence, any other evidence of paternity, or, as we would understand now, paternity or maternity. The trial counsel went on to explain there is all of this evidence in the form of a constitutional violation that has occurred to Ms. Edmonds here, and brought everything together in terms of that being
What's the statute that you're referring
relevant.
to?
I believe that's the catch-all. I believe that was the RC 311.03A, unless I'm mistaken. But the point that I want to make is that all our appellate brief does is delete that step because it's unnecessary and rely directly on the Constitution, which is a supreme law, rather than trying to fit the Constitution in and pigeonhole it under a specific catch-all statute. That's not to say that trial court counsel below is wrong. I believe it's correct. If you have a catch-all, you should be able to consider evidence of a constitutional violation.
Now, if I understand the appellant's argument, part of their argument on waiver, is that you had failed to articulate, or that your client through counsel had failed to articulate with enough specificity at the trial court, and specifically they pointed to objections in order to preserve it for our review. If you can address that, please.
Your Honor, we know that it was specific enough for everyone to understand it because, one, it's what they responded to in their brief when they indicated the would have married inquiry as being relevant, and they called it the crux of our argument. And then the second is that we know that it was specific enough because if you look to page 7 of Helen's opening brief, the very first paragraph in their statement of facts, before we had ever even filed a brief here, their very first paragraph, Section C, Statement of Facts, is all about whether the couple would have married. So there's no ambush here. They knew this was coming. They knew this was our argument. They called it the crux of our argument. In terms of specificity, that should be specific enough to preserve it. If it's clear that it's understood, that should be specific enough. I do want to touch briefly, because we haven't talked about the other set of arguments that my client has made, that trial counsel for the other side did not claim were waived. And those are the rights of the children here in this case. The children in this case have the legal right under Obergefell to be afforded the same legal protection and legal stability that the children of opposite-sex couples enjoy. In stark contrast to what Obergefell requires, legal stability and recognition for the families that these children were born into, what we've seen in this case is 5 years of litigation that's driven primarily by the assumption of one party that her wishes and desires trump not only my client's constitutional rights with respect to the children, but also even what the trial court determined was in the children's best interest. That is not a picture of legal stability. And if we are ever to afford legal stability to a family like what Obergefell requires, then these two parties need to be on equal footing and viewed as equal under the eyes of the law. If there are no further questions.
Thank you.
Thank you, Your Honor.
Thank you both for your arguments this morning, and thank you for your strong representation on this very important case. We will take the matter under submission, issue you a timely decision, and we wish everyone a wonderful afternoon. Thank you.
Thank you.
Thank you.